All right, in this video, we're going to talk about affirmative action, and then we're going to start the women's rights movement. So affirmative action is defined as a policy that is designed to address the consequences of previous discrimination by providing special consideration to individuals based on their race or gender. So these are policies that are intended to prevent discrimination and then correct the lasting effects of historical discrimination by ensuring that minority groups are appropriately represented in employment and higher education environments. Okay, so an example of affirmative action policies would be when colleges have sought to boost the enrollment of racial and ethnic minorities, okay, by allocating a minimum percentage of places to minorities, okay, within that admissions. So we are going to be looking at a few different cases dealing with affirmative action policies at universities. So the first is the University of California v. Bakke, and this is going to be decided in 1978. So this case is going to concern the use of quotas for those who have suffered past discrimination. So these are concrete percentages or number of seats, okay, when it comes to admission into this, the University of California's medical school. So in this case, Alan Bakke, who is a white man, is going to sue the regents of the University of California after he is denied admission to medical school. So he is going to argue that his academic record was superior to the 16 minority applicants whose seats had been set aside. So he's denied admission to the school. He is going to argue that he is more qualified than the minority students who were admitted, okay? And they are going to be admitted because of those seats that had been set aside. So Bakke's suit is going to be under the 14th Amendment's Equal Protection Clause. Okay, so the Equal Protection Clause meaning everyone is equal under the law regardless of race, gender, so on. Okay, so in this case, the court is going to side with Bakke. So they are going to rule that the quota system does violate that 14th Amendment right and those of the other white applicants. So they're going to instruct the school to admit him. Now, the court, okay, while they held that race-based quotas were a violation, they also affirmed the worthiness of the goal of increasing minority student enrollment. So this is going to leave open the possibility for other affirmative action plans. So we're going to look at another one. So this case is Gratz v. Bollinger, and this is from 2003. So instead of using quotas in this case, the school is actually using a point system in admissions. So Jennifer Gratz is going to be denied admission to the University of Michigan at Ann Arbor. Now, like I said, instead of using that quota system to rank applicants when it came to deciding who would be admitted into the school, the university is going to use a point system. This point system is going to be mostly based on academics. So when you're thinking academics, you're thinking about GPA as well as test scores, things like that, but also on other factors. So this includes being a member of an underrepresented ethnic group. So in this case, Gratz and the other denied applicants are going to sue the university and argue that the admission procedure, okay, so that point system, is going to discriminate against certain racial and ethnic groups and is going to be a violation of that Equal Protection Clause. Now, the university is going to argue in this case that a more diverse student body is going to benefit the entire learning community. So they are going to be arguing that by adding or making sure that the enrollment of minorities is boosted, okay, and having people from different backgrounds, different walks of life, they're arguing that that's going to create a better, more positive learning environment. So that is the university's argument. Now, in this case, the court is going to rule that that point system is unconstitutional, okay, so a violation of the Equal Protection Clause, but once again does not strike down race or ethnicity as factors in admissions decisions. So that's going to bring us to this next case, which is Grutter v. Bollinger. So Barbara Grutter is going to sue the University of Michigan's law school after being denied admission. So the law school didn't use a point system, but it did include race as a factor in admissions decisions. So in this case, the court is going to rule that the university can use race as a factor in those decisions so long as it could show a compelling interest to do so. So no quota system, no point system, but they are considering race as a factor in making those admissions decisions. Okay, so again, looking at those affirmative action type policies trying to boost minority enrollment. So yes, race can be considered, but there has to be a compelling interest. Okay, so you cannot violate the 14th Amendment rights of any individual. All right, so moving on to the women's rights movement. So the women's rights movement is going to take place in two waves, and we're really going to be looking at the second wave of the women's rights movement for the purpose of this class. But there are two parts. So the first part is going to take place during the early 1900s, so you can see here. And during the 19th century, the focus of the women's rights movement is really going to be voting rights. So we've said that the 15th Amendment gave African American men the right to vote, but up until the early 1900s, women still did not have the right to vote. Okay, so that's the first part of the women's rights movement. In the middle of the 20th century, the focus is going to shift to equality in the classroom and the workplace. All right, so the 19th Amendment, so as we said, that early women's rights movement is going to focus on the right to vote, or women having the right to vote. So the Wyoming Territory is going to grant women the right to vote in 1869. So by 1918, 15 states had passed laws allowing women's suffrage. So women's suffrage means the right to vote. If you ever see suffrage, that's what that word means. So the 19th Amendment, which gave women the right to vote, is going to be ratified in 1920. So women are able to vote nationwide. All right, so moving into that second wave of the women's rights movement. So it's really going to pick up in the 1960s. And like we said before, it's going to focus on equality. So it's going to address inequalities at work and in the home, and also protection from violence and sexual harassment. So in 1963, Betty Friedan is going to write the book, The Feminine Mystique, which you can see here, which highlights the ways in which American society assumed women were best suited for roles as wives and mothers. So this book is going to critique those popular ideas surrounding women's place in society and argue that women are actually entitled to self-fulfillment, including educational and professional opportunities. So women can be more than just wives and mothers. They can also have their education, be in the workplace. All right, so moving on, Betty Friedan is going to organize a group called the National Organization for Women, or NOW, okay? And they are going to push for feminist policy goals. So equal rights under the law, reproductive choice, workplace equality, ending sexual harassment against women, and other similar issues. So this is going to eventually lead to some legislation being passed in terms of women's rights. So the first is going to be the Equal Pay Act of 1963, which is going to require equal compensation for substantially equivalent work, regardless of gender, race, or religion. Okay, and then there's going to be Title VII of the Civil Rights Act of 1964. So we've already talked about the Civil Rights Act in terms of ending segregation in schools, in terms of ensuring that African Americans are going to be protected from discrimination in terms of employment. Okay, but it's also going to be part of the women's rights movement as well, because it's going to end that discrimination for women. So Title VII of the Act is going to prohibit discrimination in employment on the basis of sex and race. So women are going to be protected against discrimination in hiring and employment conditions and can't be treated differently from men if the difference is unreasonable. So in the 1960s and 70s, women's rights activists are going to secure those protections against discriminations on gender, pregnancy, and childbirth. And that's where we're going to stop with this lesson.